All right, it is noon. So welcome everyone to our July 2024 installment of In the Boardroom, where we're going to talk about a county's role in renewable energy siting, which I believe happens to be the topic of the first In the Boardroom that we ever hosted I think it was February of 2023. So this seems to be a very popular and an ongoing topic as well. So we're glad that you could join us today. Before I get started, I just want to make a couple of quick announcements. First, if you have any questions for Rebecca today, we ask that you put them either into the Q&A or the chat function. I will be monitoring the Q&A and chat as Rebecca will be speaking. And I believe she's speaking solo today. So I will be monitoring the chat and the Q&A for any questions you may have. And I may interrupt at certain times if we hit a certain question that I believe maybe shouldn't wait until the end if it involves some clarification of some of the points that were just talked about. And the second thing is that this is being recorded. So for those of you that may need to leave early and may miss the end of this webinar, have no fear. All of these in the boardrooms are recorded and are placed on the WCA website shortly after the webinar has concluded, along with the PowerPoint from today's presentation. So with that, I think at this point, I'm going to turn it over to Rebecca Roker, who is joining us today from Attolles Law. I'll have Rebecca tell us a little bit about herself, and then she can get right into today's session. So thank you for joining us, Rebecca.
Thank you for having me, Sarah. It's great to see you. Great to see all of our participants today. As Sarah mentioned, Andy's not able to be with us today, so you get me solo. Hopefully that we don't lose a bunch of participants because of that. But solar and wind energy systems, as Sarah mentioned, continue to be topics that we receive lots of questions on. So we thought it was appropriate to revisit these topics for this month's In the Boardroom. And you may have heard our presentation before, whether it was at the conference or the prior In the Boardroom. However, I'm going to try to change it up a little bit, and I really want to save time at the end for questions. So not only can we talk about legal questions that you may have, but really so we can talk about strategies and give all of you the most helpful and useful information possible. So with that, let's get started. There we go. We're going to do just a brief overview. And obviously, when we're talking about county restrictions, we have to talk about county's regulatory authority. So we're going to start from a very general standpoint and then slowly hone in on more specific restrictions. And then what can a county do? That's obviously what I want to spend the most time on today. So here we have, we're going to talk about the general restrictions on county regulatory authority. This is a solar project in Wood County. I thought that was a nice visual for everyone to see, what a solar project can actually look like. So again, that's it from, our friends in Wood County. All right. You may have heard Andy and I and our Attolles crew talk about the statutory restrictions on a county's authority to act. Well, you're going to hear it again because this is such a fundamental premise of everything that we talk about. So county's authority comes from Chapter 59, and it is a body corporate, but its powers are limited by state statute, and it can only do what the statutes allow us to do. So counties must have affirmative authority under the statutes or under the law to act. This is always an important component when we talk about what a county can and can't do. But interestingly, some of the cases we're going to talk about with respect to renewable energy, the court specifically raised this point. So again, you may have heard it before, but it's worth reminding everyone and worth for me, just always to remember that our authority comes from the statutes. We're going to talk a lot about preemption today, and preemption obviously is it's a component of a county's ability to act under the statute. And stated a different way, if the law vests the authority to regulate in the federal or the state law, the county or other municipality is prohibited from acting. The Lake Beulah Management District case is kind of our fundamental case that gives us a four-factor test to determine whether the local regulation is preempted by state law. So we look at, has the state legislation or federal legislation expressly withdrawn the powers of municipalities to act and to regulate? Next is, does the local regulation logically conflict with the state legislation? Third is, does the local regulation defeat the purpose of the state legislation? And finally, does the local regulation violate the spirit of the state legislation? That's kind of can be a catch-all, if you will, because it allows a reviewing court to look at what is the intent of this local regulation. What is it that the locals are actually trying to do in adopting this local regulation? When we're talking about renewable energy systems, we obviously have the general legal concepts of preemption, but there are also other specific statutes that apply to wind energy systems and solar energy systems. So I wanted to put these up and have those as a reference for you, because there may be other mechanisms in which an attempt is made to control renewable energy system siting using these other statutes. For example, you see chapter 236 is referenced here in the second bullet point. We've actually seen situations where a subdivision plat or a condominium plat will have a restriction on it that prohibits renewable energy systems. And so you think, hey, if you put it on the plat, then that is a restriction on the use of land. And the courts have said, no, that is a violation of the spirit of our state statutes that allow access for renewable energy systems. So if you're in your county, if you have an alternate idea of how you could potentially regulate, these are good places to start to see where either A, you may be able to regulate, or more likely B, places that other municipalities have tried to regulate but have been found to be preempted. Next slide is the administrative codes that are most often used when we're talking about renewable energy. Briefly, the PSC chapter 128, this is a key because it is a specific chapter that talks about what a local regulation can and can't do. So it sets forth the specific rules and the specific process that a county would have to follow if it receives an application for a wind energy system. So again, we talked about kind of the general concept of preemption. In our statutes, we have a specific preemptory statement when it comes to solar energy systems and wind energy systems. So on the screen right now are the definitions of those systems. I think it's certainly fair to say, think of what you would usually think of when we're talking about these systems, but I wanted everybody to have the actual statutory reference for those systems. 660401 is the primary statute that we look at when addressing county authority for solar and wind energy system siting. This is an explicit statute that prohibits a political subdivision, which includes a county, to regulate solar and wind unless it's expressly stated. So this is the most powerful statute that we have to address when we're talking about what a county can and can't do. And the courts have said 660401 has specifically withdrawn the authority for counties to regulate. So this is really our fundamental premise from a legal standpoint of everything else we're going to talk about. This quote from the Ecker brothers case, we're going to be talking about this in more detail, but I wanted just to kind of conclude our general discussion on those general regulatory authority restrictions with this quote, because I think it's a great quote that really encompasses what courts look at when they're reviewing local regulation. Is that regulation an attempt by locals to circumvent the intent of the statute and the policies of the statute for free access to these alternate or these solar and wind energy systems? All right, so now we're going to talk about specific restrictions on county regulatory authority. Again, those general restrictions we're talking about, the preemption concept and so forth, but now we're going to get into some of the specifics. And again, Sarah, if there's questions, I don't know if we've got questions, but again, folks, I want to kind of go through these pretty quickly. So if there are questions, please feel free to jump in. The picture here is a wind farm in Iowa County. It is the Montfort Wind Center. So again, I think a picture says 1,000 words, and there we have it. There's a wind farm. Okay, so what is the threshold of when a county can regulate and when it can't? We use the baseline of 100 megawatts as the bright line, if you will. And why is it the bright line? Because Chapter 196 tells us that if a facility could have a maximum generation of greater than 1,000 megawatts, then that party needs to receive a certificate of public convenience and necessity from PSC. We refer to those as the CPCN. So that 100 megawatt is really an important bright line, because if it's more than, then the applicant has to seek PSC approval and get that CPCN. If it's less than 100 megawatts, the PSC CPCN is not required, but the county can still regulate. So that, again, it's very important to understand that differentiation between, with that 100 megawatt bright line. And also here is just references to where we get those definitions and how we come up with that bright line. So let's say we have a project that is greater than 100 megawatts. PSC is in charge of the process. The county is involved to the extent that the county has to receive notice of the application from the PSC. And so if you are aware or not aware of a potential renewable energy project come into your town and you receive notice from the PSC, certainly that should give you pause because that is essentially the invitation for the county to have a seat at the table. Unfortunately, there are some provisions in the law that allow the county to have that seat at the table, and one of those is the public hearing. And so counties will oftentimes submit public hearing comments that state exactly what the county would like the PSC to know about this project. And so again, that while it's a limited seat at the table, a county can certainly maximize the availability of that PSC process. So what is the PSC looking at? The PSC is going to have a public hearing on the application, and the PSC must approve the application and must approve the CPCN if the applicant meets all of the 8 statutory factors. So what are those statutory factors? What are those things that the applicant has to meet in order to receive its CPCN? The PSC looks at the needs of the public and whether there is a need for the additional energy. PSC looks at the design or the route, and whether those routes are in the public interest. Are those the best routes to use, or are those alternative routes? What are some of the hardships? What are the economics and safety or reliability, and the environmental factors that should be taken into consideration? One thing I wanted to point out on this element is this is certainly one that a county is going to have some interest in, whether it be use of county roads, whether it be economic development, or impact on environmental factors. Those are usually areas that the county would have jurisdiction over. But again, jurisdiction for projects greater than 100 megawatts falls with PSC. So again, you see how these elements that the PSC has to decide certainly touch on elements that the county would usually regulate and may want to regulate. So you can, I'm going to skip over the rest of these. If there's questions, let me know. I wanted to add a note on wholesale merchant plants. The definition is here for you, but just know if you have, if there's an application for a wholesale merchant plant, there are 2 of the 8 factors that do not need to be met. They do not need to look at the needs of the public, and they don't have to look at the design and location routes, which is interesting because that, again, is one of those elements that oftentimes counties are very concerned with, given potential impact on county highways. So if you've got a wholesale merchant plant coming to your town, your involvement might be a little bit different. And the PSC's listening to county's comments may be different. All right, so what is the county's role in this PSC process? Again, we've got a project that is greater than 100 megawatts. Where does a county fit into this? The statutes specifically say that no local ordinance can prohibit not only the testing for the utility and for the project, but then also essentially the installation or the utilization of that facility. These are 2 very powerful statutes that remove authority from counties to regulate. And again, we're back to the concept of preemption. In these 2 scenarios, again, we're speaking specifically with respect to projects that are greater than 100 megawatts. These also come into play with respect to projects that are smaller and that are less than 100 megawatts. We're going to talk again a little bit more about some of the case law, but this is an important quote from an ATC case from 2009. It is a recognition by our courts that this statute expressly withdraws the power of municipalities, including counties, to act once the PSC has issued that CPCN. So again, it is so important for a county to participate in that application process before PSC, because once that CPCN is issued, the county has no ability to participate in any regulatory process. So again, it is absolutely vital that you, as a county, participate in that process. And we'll talk about that.
I have a question.
Sure.
Jump in, because the question says, based on what has been said thus far, am I correct to understand that the statewide effort being made by a certain law firm for towns and counties to adopt licensing ordinances for wind projects over 100 megawatts is futile, such as these ordinances would be unenforceable? They have requirements more restrictive than PSC 128, such as setbacks.
Great question. I think that if we could have a statute granting that specific regulatory authority, it would, I don't want to say it would trump these other provisions, but it would have to work together. Because right now our case law and the language of the statutes say, unless otherwise authorized to act. A new statute allowing a county to have regulation of those wind energy systems would be that explicit permission for a county to act. So no, I don't think it's completely futile. If it were passed, I think we would have some room to regulate, and we would have to make sure those regulations are very narrowly crafted to pass the tests that the courts have already looked at and have already established. But most importantly, no, I don't think it's futile because it would be an explicit grant of authority. So that's why we can keep our fingers crossed. So back to 660401 again, I said this is kind of the threshold statute for us. This again states that the county or a county, any municipality may only place a restriction on a solar energy system or wind energy system if it satisfies one of these three criteria. It preserves or protects public health and safety. The restriction does not significantly increase the cost of the system to the applicant or decrease its efficiency, or it allows for alternative system of comparable cost and efficiency. So you might be looking at this and saying, well, Rebecca, you just said that we can't regulate, but now we can do these things. And of course, the police power and the ability to preserve and protect public health and safety is very broad. So what does all this mean? Why can't we regulate if 660401 says we can specifically regulate on these three areas? The courts have looked at that very question. So the easy answer is that a county has to look at these proposals on a case-by-case basis. In fact, the Eckerd brothers case specifically cites the statutory language of a solar energy system or a wind energy system. So we can't have a blanket ordinance that applies across the board to all of these alternative renewable energy systems. So again, the courts have used that language of no one size fits all. It has to be very particularized. Well, how do we do that if we don't know what could potentially be coming down the road? We're going to talk about that. So within this context of that regulatory framework, counties, you are preempted from regulating, but under 660401, you can regulate if it does one of those three things. So what does that mean? What does that regulatory framework mean? The first case that we look at is actually, it predates 660401, but the statutes that it references are akin to what we have in 660401, so it's still good law. And in this case, it actually related to private property owners who wanted to have energy systems on their land and were required to get a conditional use permit. This case said, no, there's nothing in the statute that requires a person to have a conditional use permit for this system. And so therefore the local municipality can't have one, which is interesting because that has evolved. But the most important takeaway from this case is the focus on the legislative intent and again, that policy, that it serves to benefit and protect the owner of the solar or wind energy system by restricting users or owners of nearby property from creating an impermissible interference. So again, the court is looking at what rights of use does that owner of the system have? How can a municipality or how can a neighbor or how can anyone interfere with the right to use that system? Again, the court specifically referenced that 660301, which is the predecessor to 660401, is a legislative restriction on the ability of local governments to regulate solar and wind energy systems. So this is still good law, even though our statutory numbers have changed. You will note the final line as is a reference to a municipal zoning and conditional use powers, which clearly a county in 5969 has zoning authority and has the ability to use a conditional use permit to regulate land use. And we're going to talk about how those interplay in just a minute. Some additional regulatory framework. Eckert Brothers is a very important case when we're talking about renewable energy systems. This was a challenge that the county had acted in excess of its authority in the regulation of the wind energy turbine system. And the court said basically no. We cannot have a county or municipality circumvent the process. We cannot have the county regulations interfere with what the state regulations already require. And again, looking at that PSC process, the PSC is regulating something, the county can't regulate the same thing in a way that is inconsistent. Again, the court went back to those three components of 660401 and said that these are the only circumstances in which a county can regulate. And again, we've got that preservation of public health and safety, restrictions on the increase, or does it restrict cost or efficiency? And so what do we do with that? The court said, this is not an expansion of county authority. This is a limitation on county authority. So when we look at these three components, particularly number one, hey, we can regulate to preserve public health and safety. That's broad, right? The court said, no, what this is not a typical application of police power. This is not a grant of authority for counties to regulate. This is actually a restriction on even what it can do. And so that's why the court, it rejected Calumet County's argument that the legislature has authorized counties to make their own policies. It didn't expand counties' rights, it actually restricts counties' rights. Again, that applies to all municipalities. Oh, question, yes.
I hate to, before you get on to the next slide here, and I see apparently you're still on the same thing, but there's a follow-up question to the previous question with
Sure.
regard to that, the licensing ordinances that counties are being lobbied to adopt. They wanted to clarify that the ordinance would state that a wind developer must get a local license and meet the local setbacks, which are greater than that within PSC 128. In other words, they believe that it appears that it's a licensing ordinance, but they don't have any statutory authority. So I think the question, I think there's a clarification about, that the counties are being asked not to, support statutory change, but instead they're being asked to actually adopt a regulatory ordinance. And maybe you're not familiar with what folks are being asked to adopt either, and we can certainly work with the person asking the question to get that to you.
Yes, absolutely. I'd be very curious to see what the county is being asked to adopt. I think I may have a hunch of what this relates to, and the party from which it was generated. No pun intended. And that is something that we have to be very careful about. And this applies to any issue. If there are outside groups that come to the county and say, hey, we'd really like you to adopt this resolution in support of X, or we think it is appropriate for you to adopt this ordinance regulating via a license to or do Y. Always be very cognizant of what the information that you're given. Oftentimes those legal interpretations that you receive from those interested parties is not correct, or it's maybe leaving something out. So certainly work with your corporation counsel to carefully analyze what you are being asked to do. But yeah, I would love some follow-up or some additional information on that particular question. Sarah, were there any other questions that we should tackle first before I keep going?
Hey, there's one other question, but it doesn't relate to what we're talking about right now. So I was going to hold that one off until the end.
Okay, sounds good. All right, next slide then. So this quote from Eckert Brothers just reaffirms the fact that the provisions in 660401 in those 3 points are not an expansion of a county's ability to regulate, but more a restriction. And so when a county does regulate, it has to be on a case-by-case basis. We can't have that catch-all, one-size-fits-all type of provision. And how do we do that? This court specifically referenced that conditional use permit process, which appears to go against the last case that we talked about. But again, the Eckert Brothers case shows us that we can use a conditional use permit to the extent we're not regulating in a way in which we're preempted, so long as it's on that case-by-case approach. So, well, again, we'll talk about more on those points in a little bit. But again, the underlying message is that the courts recognize that state policy is to have access to these renewable energy systems. And there are restrictions on what counties and political subdivisions can do. And the Eckert Brothers Court went so far as to say, make your arguments to the legislature, which to change the law, which is kind of a unique thing to hear from a court. Usually they're not that direct, but interesting quote. Okay, one other case to talk about the regulatory framework. This is the ATC case out of Dane County. In this case, it would, again, the court emphasized that the legislature has expressly withdrawn a county's ability to act once the PSC has issued its CPCN. So again, that underscores the importance of being involved in the PSC process. And so get involved early as you can. Okay. The big question then is, so what can a county do? All right, Rebecca, you've been telling us, for over a half hour what we can't do. Let's talk about what we can do. There are provisions in the statute that allow some regulation. We can, under 660403, counties can choose to enact certain restrictions on renewable energy systems. In these kind of 3 circumstances. Number one, the trimming of vegetation. And I always have to chuckle when I hear that, because I think, we saw a picture of those systems in Wood County and Iowa County. And okay, legislature, you're telling us we can regulate trimming of vegetation. Thanks. That makes us feel so much better to protect our constituents. But as the case may be, we can have ordinances that regulate trimming of vegetation. We can have access permits. And when I hear access permits coming from, my DOT world, I think, oh, like access to roads. No, access to the energy, access to solar power and access to wind. So a county may adopt access to those energy sources, permits. And then we're going to talk about zoning permits. How does zoning fit in to this whole scheme? Every single ordinance that the county has, even if it's a vegetation ordinance, an access ordinance, or a zoning ordinance, they are all subject to preemption requirements. So you can't use one of these mechanisms to curtail what would otherwise be preempted. And the best example to illustrate this is the use of a conditional use permit. This is just a re-emphasis of what I just said. Any ordinance is subject to preemption, and we can't get around the restrictions that we have in 660401 or 0403 by adopting a conditional use permit requirement that is more restrictive. So even though Eckert Brothers told us, yeah, you can use a conditional use permit to hit on that case-by-case approach, we can't do it in such a way that we are trying to regulate what we are otherwise preempted from regulating. These points, I won't read through these, but just keep in mind what Eckert requires us to do. We can't have a one-size-fits-all. It has to be a case-by-case approach. Your legislative or your ordinance has to be specific enough that it is looking at systems on a case-by-case approach. The conditions that are in 660401, again, primarily that 1A, which is the public health and safety, that is not a permission to utilize a very broad zoning ordinance. That is actually a restriction on what counties can do. So keep those things in mind if you are looking to use your zoning authority to regulate the renewable energy systems. I wanted to include a reiteration of what was in Act 67 and 5969 5E, which is the conditions or what we can't do or can do when issuing conditional use permits. I won't read all of these, I'm sure, but again, I wanted you to have them for later reference. Just keep in mind that 5969 5E sets forth very specific requirements for what a county can and can't do when reviewing a conditional use permit application. We have to have things like substantial evidence to justify any conditions that are placed. If an applicant agrees to any conditions, we have to issue the permit. And so 5969 5E is very important within the context of renewable energy siting, because again, if we can use a conditional use permit as a tool to regulate, we still have to comply with the restrictions in 5969, again, relating to substantial evidence and being able to measure data that is the justification for any conditions. Okay, we're back to trimming.
Oh, Rebecca, we have a question.
Yes, great.
We're asking if you could please expand on the access permit, and can a county find a way to use that as a revenue stream?
Great question, and I actually have a few slides on that. So if I can punt on that question, and then I'll make sure I touch on that. And we are going to talk about revenue streams as well. So again, trimming, this always just kind of makes me go, great, we can regulate trimming. Thanks. But again, in 660401 sub 2, we have specific authority to adopt ordinances regarding the trimming of vegetation. These, and keep in mind too, you don't have to adopt these ordinances. These are, you may choose to adopt the trimming ordinance, but you are not required to by the statutes. Access permits. Access permits, again, we're talking about not access to roads, we're talking about access to sunlight and access to wind in order to generate that power. So 660403 allows the county to adopt a requirement for an access permit. 660403 is very specific in terms of what a county can and can't require. And it's very specific in terms of the standards for approval. This is an attempt at a statutory scheme to allow some regulation by municipalities, but having those very strict guidelines for regulation. Again, similar to just general conditional use permit authority under 5969 5E. Yes, you can regulate, but there's very specific standards that you have to follow when requiring an access permit, and then when reviewing an application for an access permit. There's specific notice requirements that are set forth in 660403. Again, very detailed as to what a county and an applicant have to do in that access permit process. So I'll flip through these pretty quickly because we don't just, the takeaway is know that there are very specific requirements. The notice requirements in particular are very specific. And if they're not complied with, if the county fails to comply with any of these requirements, a court would likely find that it didn't follow the process, and so therefore its regulation is not legally sufficient. Again, just more requirements that are set forth in 660403 for your reference. Just know that they're there. Now we get to the restrictions on what a county can do when reviewing that access permit. Again, the default is the county shall grant the permit if it's determined that the granting of the permit will not unreasonably interfere with the orderly land use and development plans of the county, and that no person has demonstrated that he or she has present plans to build a structure that would create an impermissible interference, again, with those rights to sunlight and wind. And the benefits to the applicant and the public will exceed any of the burdens. So if a county and agency relates to the land use agency, so not agency being PSC or a state regulatory agency, if the county finds that these three elements are met, the county has to issue that access permit. If somebody is aggrieved by the county's decision, they can appeal that decision to a circuit court. So if you've got a neighboring property that is determined to be aggrieved, that person would be deemed to have standing to challenge the county's decision. Again, a few more points on the access permits. Just as there are very specific legislative points on what we can do, there are points on what we can't do as well. We cannot require an owner to obtain a permit prior to installing a solar collector. The justification is that the permit is a benefit to the owners intended to promote the investment and the use of those renewable energy systems. So again, it circles back to that policy and that statewide policy of promoting renewable energy systems. So this point is a good way to underscore that, or the application of that holistic policy of we want to encourage renewable energy. Let me just keep going here. I do not want to run out of time. More requirements for the access permits. Again, for your reference, in the statutes, very specific. We got to make sure we follow them. Any questions, you can, certainly reach out to us or your court counsel. 660403 also has very specific termination provisions. So once an access permit is granted, how does it terminate? Clearly, if an access permit is granted, there would be concerns if a county or municipality just comes in and terminates it. What rights does that permit holder have to that permit, and what steps does a county need to take if it's looking at terminating that permit? Here we are. This is the important part, and we've got 16 minutes. Excellent. I was talking to Andy earlier, and I said, Andy, maybe we should just start with this slide, because I'm sure this is what people want here. And this frankly is the fun part for us in coming up with strategies of how you can regulate do so within the context of state law, but do so in a way that is still beneficial for your county and the constituents, and the people that live and visit there. So what can we do in light of all of these specific and I'll say massive statutory prohibitions and preemptions on county authority? The first thing that we always recommend is take a look at your existing ordinances. Even if you don't know of an application coming to town for a renewable energy system, look at your existing ordinance and make sure that they are up to date and that your comprehensive plan is up to date and legally sound. Are there outdated provisions in there that would inappropriately restrict solar or wind sightings? If you can get your ordinances on firm ground, that is the easiest and most appropriate step to be able to regulate if you do receive an application. So that's something that everybody could do, even if you don't have an application coming to town. If there is a proposal that comes to town, the best thing you can do is start discussions early. You may receive notice from the applicant themselves. You may hear about it through the grapevine. Regardless of how you find out, the sooner that you can meet with the applicant, the better. I would assume, and I think it's safe to assume, that any applicant that comes to your county is going to understand the preemption and the limits on county regulatory authority. But that being said, the PSC process still requires including the county in that process. So they require an applicant to communicate with the county. That is essentially your foot in the door to be able to have a seat at that PSC table. Also, the sooner that you can have those discussions with the applicant, and the sooner you can have discussions with PSC, the sooner PSC, and I think the better understanding PSC is going to have of all of your local concerns. So when we talk about local concerns, certainly, every county is different in terms of environmental impacts and environmental conditions or characteristics. Maybe there are other particularized land use issues, water protection. Perhaps you have, your soils. Perhaps there's some component of the land in your county that makes it very unique. This is the opportunity for you to say, hey, PSC, you need to make sure that you look at our soils testing because we are very concerned that this is not going to be an appropriate use of this land. Again, you can't regulate those types of things independently. The door to that regulation is through the PSC and communicating with the PSC to make them hear you on these issues that are important, i.e. PSC considers them in its review of the application. So again, start discussions early and have the discussions with the applicant and have the discussions with the PSC. The next point is interesting to know what is not required of your county. We're working on a project right now for a county that has a solar proposal coming to town and was told that the county has to oversee decommissioning. Yeah, it's convenient for the applicant to have the county oversee the decommissioning, but it's not statutorily required. And so when you are asked to do things as part of these applications, have a good understanding of what you don't have to say yes to. I think that applicants or just folks in general may assume, well, the county has the best tools to oversee this process, so we'll have the county do it. That's not necessarily the best way for the county. And certainly if there are impacts on resources and staff time that, you know, the county has to essentially spend money to oversee a decommissioning process. Now, there are ways, and we're going to talk about the joint development agreements in a second. If you are requested to oversee decommissioning, you certainly can request compensation for that. And as I would highly recommend that you do. But even if an applicant is willing to pay the county to oversee that decommissioning, you don't have to do it. So again, keep in mind what you are not required to do. So now let's talk about revenue sharing. This may touch on the question regarding the access permit and the question on revenue sharing. The concept behind the revenue sharing statutes is because these renewable energy systems are off the tax roll. This is a way to compensate local municipalities for that loss of tax revenue. So there is a statutory formula that sets forth how much revenue is shared by a county and how much is shared by a city or village, or if the system is in a town, how much is shared between the county and the town. So that is a statutory formula. However, in this process of these discussions, we're going to start early. You can always negotiate for a higher percentage of shared revenue. There is nothing in the statutes that prohibits a county from asking for a greater percentage of that shared revenue from the applicant. And they could say, no, you can't force that as a component of your review and approval, but you can ask. And again, that's why those early discussions are so important. Another point, and I'll look at creative solutions. Again, if you've got unique characteristics of a piece of land or within your county, look at alternate agreements that you could use to regulate what you need to regulate that would be legally permissible. The one that I've seen and I really like as an option are land leases. So if a county owns property, and we see this a lot for cell towers, use that land lease as the mechanism to regulate what you may not otherwise be able to regulate. Now, does the applicant have to agree to those things? No, and you can't force them. But as a landowner, you certainly can say, hey, these are my terms. I don't have to lease you this land. So it puts a county in a really good negotiating position, again, to be able to regulate those unique characteristics of the property in your county. So I guess maybe stated a better way is think outside the box. You know, let's be creative with different ways to be able to hone in on those regulations, those items we want to regulate. The most common way to get that alternate regulation, if you will, is through a joint development agreement. And, you know, in looking at this list, I should have put this one first because the joint development agreement really is the vehicle in which the county can make demands. And it's an open negotiation. So can you force? No, but you can certainly talk. This is the mechanism where we see agreements with respect to road access. Now, access permits in terms of road access or oversized overweight permits for county highways, you can't do. We can ask for them in the joint development agreement, and we see a lot of times applicants will agree to comply with the county road access requirements. You can negotiate cost reimbursements. In one of my favorite projects, we were able to have professional fees, legal fees, engineering fees reimbursed by the applicant. Now, that's not guaranteed, but you can ask for it and you can try to negotiate the best package possible for your county. You can set forth insurance requirements. What insurance is that operator required to have to protect the interests of the county? And again, negotiation of the decommissioning requirements. If the county doesn't object to overseeing decommissioning, what are you going to get paid for it? You should get paid for it. Let's put that in the joint development agreement. So when we're talking about alternate options for the county, we got to think outside the box because we have this very restrictive preemption that we have to deal with in the statutes. But we can think outside the box and we can enter into development agreements with these applicants. And this is good old fashioned negotiation. And hopefully the applicant is willing to meet partway, halfway, and hear the demands. But there can be success for counties. So even though we have this very stringent statutory scheme of preemption, when we're talking about renewable energy projects, there's other things that we can do. We just got to be creative. We just got to negotiate well. And all of these points are, the tips that we find are the most effective to be able to do that. So that's, we just kind of say that's kind of the glimmer of hope, if you will, for counties when in a situation where hands are tied, certainly to the extent that we can regulate. So 4 minutes. I only saved 4 minutes for questions. Do we have more questions, Sarah?
Yes, we have 3 questions so far.
Okay.
As we're going through these 3 questions, if other folks have questions, please feel free to add them to the chat or the Q&A, and we will get to them as soon as we can. So the first question, are counties, towns seeing damage to the road networks for the construction of solar arrays? And if so, how is the damage to the roads divided equitably between other types of vehicles, such as farm equipment, milk trucks, or logging?
Great question. I have not been involved in a situation where we've seen post-development damage. Fortunately, hopefully that means we haven't had those situations, but where we come across that issue is in the joint development agreement. Usually we will have a baseline test of road conditions prior to development, and then development will occur. All of those gigantic panels will be brought in. Then we'll do a test of the road condition after. If there is a difference, then the applicant has to pay for the repair of those roads. Now that is specifically the construction process. After construction, it's much harder to be able to do the before and after. So then it becomes a question of, will the applicant agree to apply for an oversized overweight permit for the use of the county highways? So it may be a similar regulatory scheme as other oversized overweight uses like the milk trucks, the timber trucks, so forth. But let's try to get the applicant to also agree to those provisions, so we have that uniform regulation of weight on the county highways.
All right, thank you for that. Here's the next question. Can a municipality or county require funds to be put into escrow by the developer for decommissioning, especially since these companies may not exist in 20 years?
Yes, great question. And yes, you can require that. Particularly with respect to, I don't want to say fly-by-night companies, but we all know that if we see a trend in development, that trend may cease and those companies may cease. And if you don't have some security, how's it going to be paid for in 20, 25 years? So we see things like letters of credit, bonds. Certainly you can ask for an escrow. Whether you can force an escrow is, to me, is a different question. I certainly, if we were asked, we want an escrow, we don't want to do a letter of credit, can we absolutely demand that? I don't know. So if there is an actual, if you want me to answer that, the question, I can look into that in more detail, but whether a county can specifically demand only an escrow payment rather than a letter of credit, I don't know. But I do know that the county can demand financial assurance, and that can take the form of an escrow payment.
All right. Can you, here's the next question. What about sharing revenue with schools?
Good question. I don't know whether schools are included in the statutory revenue sharing formula. I can look at that if somebody has that specific question. So I don't know whether school districts play into that. Certainly, you would have the authority to allow that sharing with school districts. There's nothing in the statutes that prohibits that revenue to be shared by a county to not be further shared, like with a school district. It could take the form of an intergovernmental agreement that is, you know, even outside the context of the joint development agreement. But yes, you can there's no statutory prohibition on further sharing those funds if you would want to share them with a school district. But whether a school district is included in the base formula, that I do not know.
Okay, and then I'm seeing one final question here. Can a county ordinance for solar battery storage require recoupment for lost property tax revenue? And if so, is it limited to the statutory formula amount? And where is the formula found?
So solar battery storage, I think the first question would be whether that solar battery is a solar energy system, because the statutes prohibit us from regulating solar energy systems. So if we're talking just one component of the energy system, that's not the whole thing. So if, let's say it's the battery is a, you know, it's a really heavy part, and it is separate from the energy system itself, then yeah, I think you can regulate that. If it is immediately adjacent to the solar farm, then the question is, well, maybe the battery is part of the solar energy system. You know, it depends on the facts there. What was the second part of that question, Sarah? I forgot.
Second part, let's see. Recoupment for lost property tax revenue, and if so, is it limited to the statutory formula amount?
So if that
battery storage requires recoupment, or can the ordinance?
Okay, so if the battery and that the storage of the battery was deemed part of the solar energy system and would therefore be considered part of that system and therefore not be subject to property tax, then yes, the statutory revenue sharing formula would apply. Where do we get that from? That is promulgated by DOR, Department of Revenue. So that's where we go to find that formula. I think a lot of the other components of that question really depend on the facts too. Like, where is the storage occurring? Under what type of ordinance? Is it a land use ordinance because you are storing industrial equipment in an agriculturally zoned district? So there's a lot of other elements that may come into play. But again, to kind of generally answer the question, the threshold question is whether those batteries would be deemed part of the energy system. Because if they're not, then we can look to, you know, increase county regulation.
All right, thank you, Rebecca. I am not seeing any other questions, and I believe we are out of time as we are past 1 o'clock. So Rebecca, I want to thank you so much. I think I learned a lot today that I never knew about this stuff. And I think that you provided a lot of really good information for the members and things for folks to think about. So just as a reminder, our next in the boardroom will take place on Wednesday, August 28th, where we will talk about electioneering. And I believe this is the first time we are going to talk about electioneering and, question and address questions around the regulation of workplace conduct when water cooler conversations turn into heated debate and campaign materials find their way into employee workstations. So we're going to talk about these issues, which can be very tricky under the First Amendment. So I really look forward to seeing everybody back on August 28th, where again, we will be joined by Andy and possibly Rebecca again to talk. No?
I think Matt Tome is going to be
Oh, man.
co-hosting with Andy on that one.
Good, good. We will see Matt. We don't see Matt very often. So
Yeah,
at least not in the boardroom series. So perfect. Join us again August 28th. We will send out multiple emails providing you with the link to sign up for the August in the boardroom. Otherwise, thank you so much for joining us today, and feel free to contact either Rebecca or myself if you have any additional questions. Thanks and have a good day.
thanks everyone.